Really, it's a reading off of jury numbers, right? Like I said, it's a striking process. It's not Carter and I judge would really like juror number 304 on our jury. That's not the process. It's, hey, this person might have said this in the process, so we're striking that individual.
This is Hollis Wright Managing Partner Josh Wright, and welcome to the Verdicts In Podcast Season 4. Here, our experienced attorneys break down the hottest legal stories making headlines and connect them to real cases from our firm's files. Each episode dives into current events, landmark verdicts, and trending legal debates, giving you practical insight into how law really works for you and in the real world. With candid conversations, expert commentary, and behind-the-scenes stories from active and past cases, The Verdicts In gives listeners a front-row seat to the intersection of news and personal injury law. Plus, in every episode, you'll pick up valuable legal advice straight from the front lines that can help you in your everyday life. Subscribe to The Verdicts In podcast wherever you get your podcasts and get great legal insight without the legalese. The Verdicts In podcast starts now.
Welcome to the Verdicts In podcast. Thank you so much for joining us here today. We've got a great topic with Craig Shirley, attorney in our office. Craig, we're going to be talking about how jurors' answers in Voire Dire can impact a case. So if you're from the South, we say Voire Dire. If you're French, it's Voire Dire.
That's right. I never say it the fancy way. I'm always Voire Dire.
Well, and actually that means to speak the truth, right?
That's what I've been told.
Yeah, absolutely. You know, our viewership and listenership would go off the charts if we actually changed the title to How Jurors' Answers in Voire Dire Could Get You Off of Jury Duty.
That's exactly right. Yeah.
That's really what the people want to hear, right?
That's true. There's a lot of ways to do it too.
We all have friends that get those summons in the mail that tell them they've got to show up for jury duty, whether it's federal court or state court, and then the onslaught of phone calls begin. How do I get off?
How do I get off? Nobody wants to do it. I think everybody appreciates it, but it's one of those things nobody really wants to do it, but we need it.
Well, and interestingly enough, non-lawyers often get the comment where they'll say, well, I'm just going to go in there and sit there and say nothing, and I won't be selected. You know you're talking to somebody that really doesn't understand how the jury selection process works when they think that.
That's exactly right.
It's actually, truthfully, just the opposite. The more you say, the more likely it is you'll be struck,
yes, right? Yeah, and we always encourage people to talk and answer the questions, so it's interesting to see the ones that we get that are overly talkative, and then some you just can't pull answers out of them for anything, so it's interesting.
Well, the French name for it is actually interesting, to speak the truth, because when I do jury selection, I always emphasize both of those parts, which is, number one, you have to speak, right? You have to raise your hand and speak up if you have an answer to a question. And then also it's very important that you tell the truth and that you give accurate answers, because obviously the lawyers are going to be taking that information and making decisions on who they're going to strike from the jury. It's actually kind of a deselection process, if you will. Well, let's jump in. So just talk in general, what is Voire Dire? How does it play a part in the cases that you handle?
Sure, and so, we handle these cases from when the client first calls us, sometimes all the way through a jury verdict. It's a lengthy process, and, there's steps along the way. You file your lawsuit, you have discovery, written discovery, you have depositions, experts, but then when we get to the trial, there's a process all in and of itself as well, and that first step is the Voire Dire process. And you mentioned it, some people call it jury selection. It's kind of a misnomer. You're not picking and selecting the jury members that you want on your panel. It's more of a getting the information and striking the jurors who may not be the best fit. So it's the first step in the process of ensuring that you have those impartial, fair jurors that are going to sit there and listen to all the evidence and ultimately decide your client's case. And it's the first time that you get a chance to talk with them and kind of workshop the issues that you've outlined and uncovered throughout that lengthy litigation process.
Yeah, and I would make the argument that after 26 years of practicing law, this is one of the most important, but oftentimes overlooked aspect of a trial, because as you know, we're all consumed by opening statements and direct examinations of our witness and cross-examination of the defendant's witnesses, and sometimes the jury selection process can be overlooked, but that's a very dangerous thing to overlook, and it can have devastating consequences to your case, because when you think about it, that process should honestly be one of the most important things that you focus on going into a trial, because they're the ones that are in control of your client's fate and the outcome of the case.
Yes, and you know, to speak about how important it is, I wish we had it when I was in school, but Cumberland now offers a class that they teach semester long on nothing but jury selection, I think is the name of it.
Oh, wow. Yeah, they didn't have that when I was there.
Me either. And
But people also didn't have laptops in the classrooms when I was there.
Yeah, we transitioned away from the stone tablets since your time. But no, it's super important. It's really the bedrock, the foundation of our justice system. You know, the jury system is there for folks that, you know, we have a constitutional right to have our case heard by a jury. And so that Voire Dire process allows us to figure out the 12 best jurors that will be impartial, that will be fair and unbiased in deciding those issues. And if you don't do your job as an attorney and you do overlook the Voire Dire process, it can be detrimental, because, you know, if you don't do the process right, you don't ask the right questions, you don't identify the right issues to ask the questions about, you could have a juror that gets on there that could torpedo the case, not in the fact that they're doing anything wrong. It's just, if I would have taken this more seriously, maybe I could have figured out that juror was not impartial, but was partial one way or the other, and we could have kept that person off the jury, and they could have been on another jury somewhere else.
There have been so many different TV shows, Law and Order just to name one, but almost all of these legal-related TV shows, you're watching thunderous cross-examinations or opening statements or closing arguments. The Voire Dire or jury selection process is generally very foreign to lay people when they come in and you go through that process. It's not something they've ever seen before on TV or ever experienced unless they've had jury duty before. Talk a little bit about the individual's role, the juror's role in coming in and making sure they're paying attention, answering questions.
Yeah, and you know, a lot of people, I think the reason it's overlooked is it's not a very interesting, I guess you could say, part of the trial as would a cross-examination or a closing argument be. But the role of the jurors is to come in, and we want to again make sure that we have a fair process, because we don't want, as much as it would benefit us, right? We don't want 12 jurors who are all going to lean towards a plaintiff no matter what, right? That would help us, but that wouldn't be fair. Same way we wouldn't want 12 folks who would always lean towards the insurance companies or the corporations or the entities, because that wouldn't be fair to us. So when the individuals are summoned for jury duty, right, you come in and the court does a fantastic job. The judge goes through and explains the process and most of the time allows the attorneys to ask, you know, very broad and very nuanced, and a lot of times it's a lengthy process of questions that the juror members are encouraged and in fact required to answer out loud and to give truthful responses. Because, you know, like we tell them all the time in jury selection is, nobody's gonna think you're a bad person for answering anything a certain way, because we are all humans, and our experiences, both lived, actual, and what we go through in our daily lives affects us, whether we identify it as a bias or not. It makes us who we are. And so it's important that when you're going through the process and you're summoned for jury duty, that you listen to the questions and you answer them if they apply, right? I mean, there may be a handful of questions that somebody asked, one of the attorneys asked, that just doesn't apply to you. They may ask about who all has children here, right? And if you don't have children, then there's really nothing to offer. It's not like you raise your hand to say, I don't have children. What would you like from me now, right? And so that's the importance of it, is just getting down to the nuts and bolts to figure out who would be best to serve on this particular jury in this case, in this courthouse at this moment.
Yeah, one of the things I like to do is I like to put the jurors at ease. We want them to feel comfortable.
Yep.
We don't want them to feel like we're prying into their personal lives. In fact, one of the aspects when I do jury selection from the outset, I let them know that if we are asking a question that would cause them to have to give some type of a response that might be embarrassing to them or of a private nature, that we'll have the opportunity opportunity when we take a break. They can come up, they can line up, and they can talk to us in a more private setting to disclose what they need to disclose. But the bottom line is everybody, including me, you, the judge, the bailiff, and everybody who's called to jury duty that's sitting out there, we all come into the courtroom with different experiences. I like to put it this way, we all have baggage.
That's right.
Right?
Yeah.
Everybody does, but it's important for the lawyers to know what that baggage looks like and is, to get an understanding of their background so that we can make a decision on behalf of our client as to whether or not they could be fair or impartial.
Right, and it's the way that I talk to folks too is because, we run around or run into at some points the jurors that you mentioned that are oversharers, and they talk and they want to help participate, and that's all well and good. Every now and then we run into the jurors that will do and say anything they can to get onto a jury, right? And they just say, I want to be on this one, I want to rule this way, and they may cater their answers and responses to try to ensure that. And, I always remind folks too, is like there may come a day where you need an impartial jury, right? And you don't want one of your veneer members trying to get on your case to rule a certain way either, right? And so it's important to come in, answer the questions, do what you're asked to do, and then, like I said, it doesn't make you a bad person if you're struck from that jury. It just means that you're going to be a better juror for a different case, for a different set of facts and circumstances.
Yeah. Great conversation, Craig. Let's step away, take a break for just a moment. And just as a reminder, if you need to get in touch with us here at Hollis Wright, you can always call us at 844-LAW-TALK or our local number, 205-324-3600. Also, visit our website. We have a lot of information on there about our lawyers and about our practice areas here at Hollis Wright. You can find us at hollis-wright.com. Stay tuned. We'll be right back.
Hiring the right law firm may be the most important decision you make after an injury. Hollis Wright is built for that moment, built to take your case all the way and to restore you to you. Let Hollis Wright tell your comeback story.
The attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show in 2011, my goal was to do what our firm does best. Help people answer questions related to real-world legal issues they have in their lives in a way that's not intimidating to talk with a lawyer. If the issue is important to you, it's equally important to us, and we're ready to talk with you at no cost.
Yeah, oftentimes people are confronting various legal issues in their lives that really run the gamut of a lot of different legal practice areas, such as bankruptcy, criminal law, civil law, such as personal injury, divorces, domestic relations. And to be able to have a show once a week that covers those practice areas and answers people's questions in those areas, that's really the main objective of the show.
We use the resources of the many lawyers at our law firm to create a plan that has a lasting impact for each person that calls or texts. And we also give back to the community at the same time. We are here to serve you, the viewer, each week on The Attorneys.
Welcome back in here with Craig Shirley talking about the jury selection process. I'm Carter Clay. Really good conversation we're having here today.
Yes, important stuff to cover. For sure.
Absolutely. Well, let's jump right back into it. Talk, if you will, because I know you've had some situations and examples that you've experienced before, but talk about some recent cases or examples where you had some great information to share from the jury selection process.
Yeah, and one that comes to mind is, I think you might have mentioned it in one of the episodes as well, is the recent case that you and I tried down in Montgomery County. And for the listeners that don't know, we were able to secure a $2.5 million verdict on behalf of our client. And, our client was T-boned after a police officer was excessively speeding, ran through a red light, and seriously injured her. And so we filed that lawsuit against the police officer individually and against the city of Montgomery. And so, going back to what I was talking about, is through the litigation process, you uncover these issues that you're going to have to talk to the jury about to see if they may lean one way or the other. One easy one in that case was, we want to know, is anybody law enforcement, right? Because it doesn't take much to see how someone who is law enforcement may have a partiality to law enforcement. Same thing for, if we're wanting to know, is anyone married to or related to law enforcement? Because while you may not be law enforcement yourself, if you're married to a police officer or related to a police officer, you may find yourself wanting to lean one way or the other towards the police officer. And again, that would make you not impartial, right? It would not be fair to either party. It's the same reason why the defense in our case would not want anyone on the jury who had been hit by a police officer while they were in a police vehicle, right? And so those are some important things in the real world context that allows you to kind of put it into practice of, this is the stuff that we need to know. Because if we went into that case and we didn't ask those questions, we may had a police officer on our jury and not know about it. And that would not have been doing our client any favors, right?
Yeah, absolutely. Well, so talk a little bit about the process. So, and we can use that case that we tried as an example, but typically you're going to wind up with 12 jurors. Sometimes you may have an alternate or two just in case one of the primary 12 were to drop off, get sick, couldn't come to court. But generally speaking, and a lot of times the judges will talk to the lawyers about how many venire members or jurors we need to strike a jury from. But generally, let's just say it's going to be 36 to 48 potential individuals, and walk us through kind of the striking process and how you get down to those 12.
Right, and so depending on the number of the venire members and how many, if we're going to need 12 or 15 jurors, the parties will talk with the court about, all right, how many strikes does the plaintiff get? How many strikes does the defense get? Plaintiff will go first, and then defense will have the last strike, and then we'll go from alternates from there. And so, really, it's a reading off of jury numbers, right? Like I said, it's a striking process. It's not Carter and I would, judge would really like juror number 304 on our jury. That's not the process. It's, hey, this person might have said this in the process, so we're striking that individual. And you just go back and forth. We strike, the defense strikes, we strike, the defense strikes, until we get down to that number of 12 to 15. And there are a number of issues of why a potential jury member may be struck. One of the things that Alabama law has done over the years is both through statutory legislation and through case law is they have identified certain areas, situations, or criteria, if you will, that shows that we as humans, whether we believe it or not, there are certain experiences or situations that would make us inherently biased one way or the other, and those are when you can exercise your strikes for cause. And so there's a lot of those. A lot of them are self-explanatory. Really, they're common sense. For instance, you have to be an adult. So if you're not over the age of 19 under Alabama law, you can't serve on the jury. You can't be related to one of the parties, right? They're not going to want our client's mom on the jury deciding the case, and can't be related to one of the attorneys, because I can tell you they certainly wouldn't want my mom on the jury trying to decide the case, right?
Well, and I think in that case, we actually had a City of Montgomery employee
That's right.
that was one of the jury venire members, and we got them struck for cause because the law says, obviously, if you're an actual employee of the city, it assumes that you can't be fair to the other side.
That's right. And, we have cases where we have to sue the insurance companies at times, right? And the law says that if you're insured by the same insurance company, you may not be partial when deciding, I don't want my insurance company being affected by this. How's it going to affect my premium? So that's another way.
You said it very eloquently, but the bottom line is that both sides have essentially 12 opportunities to get rid of people they don't want on the jury. And the ones that you don't get rid of, or that they don't get rid of, they actually are the ones.
That's the jury.
That is your jury.
Yep.
That is your jury.
Yeah, it's a good process. Like I said, it doesn't say that you're a bad juror if you get struck, a bad person, or you're downplaying whatever experience that had or bias that you had. It's just for this particular case, you weren't the best juror. You're going to be the best on another case with a different set of facts and circumstances.
Yeah. Let's take a break. Our final break. Great conversation with Craig Shirley here. And just as a reminder, you can also follow Hollis Wright on just about every social media platform that's out there. And our team does a great job of downloading these podcasts to just about every platform that you can get podcasts from. We're in season 4. If you're enjoying this podcast, check out season 1, 2, and 3. There's probably a lot of podcasts in those seasons that you will enjoy as well. Stay tuned. We'll be right back in a minute.
Victims think they're not strong enough to take on a corporation or an industry after an accident. And I'm here to tell you, with us at your side, you are. Don't be intimidated by anyone or anything. Let Hollis Wright tell your comeback story.
Honestly, we don't love all the legal advertising we see, but some firms are simply built different. If you want a firm you can be proud of, one that doesn't stop until we win, well, you found it. Let Hollis Wright tell your comeback story.
Welcome back in. Final segment with Craig Shirley talking about jury selection, what you need to know if you are summoned and have jury duty. This will help out in terms of making the process go smoothly. Craig, we have not talked about this yet, but I think it's important to highlight for the listeners and viewers the potential consequences of the lawyers not asking the right questions to get answers from those jurors, not being precise and specific with the questions to get responses, and how that can play out and negatively impact a case and a result. And I know this is something that had just come up recently. There's been an Alabama Supreme Court opinion that came out on this topic. Share with everybody a little bit of the background of that case and how it affected the outcome.
Right, and so that was a case that the Alabama Supreme Court decided just in October. And so just kind of a background of it was down in Mobile County. The plaintiff had sued a large automobile manufacturer, claiming that there was a defective airbag system in the vehicle. And when the plaintiff got into a collision, the defective airbag system caused very serious and significant injuries. So they went to trial. The trial lasted, I think, upwards of maybe 2 weeks. And Carter, you know, with these defective airbag cases, they're time-consuming, they're difficult, they're expensive, they're just tough product liability cases in and of themselves without having to deal with the issues that came up in this case. So ultimately, after the trial, the jury came back with a jury verdict, a substantial amount of $8.5 million against the manufacturer and for the plaintiff. But here's where the problem came in, and it starts all the way back to the beginning of the trial and the Voire Dire process. And I mentioned earlier that most times the plaintiff starts by asking the questions. It was the same case down there. The plaintiff's lawyer in Voire Dire started asking the venire members different questions about different issues that they had identified. One of the questions that the plaintiff's attorney asked, it was, had anybody in the venire ever been sued? Right? He was wanting to know, had anybody ever been named a defendant in a lawsuit? And for purposes of brevity here, all of the venire members remained silent, right? Nobody raised their hand. Nobody answered that they had been sued or been named a defendant. After that, they go through the trial. The verdict comes back. Well, it turns out that the defense attorneys had learned that in that Voire Dire process, in remaining silent, two of the members who actually sat on the jury and returned the verdict may not have answered completely truthfully. Right?
Good lawyering by the manufacturer's lawyers. You know they were
exactly
scrambling around to try and find anything they could since they had been hit for $8.5 million.
Anything and everything. And, you know, as soon as the plaintiff's attorneys got that, too, they started scrambling. That's a lot of work. That's a lot of time. You know, they were celebrating, too, and then to get hit with that through no fault of their own, right? And it turned out that two of the jury members had actually been sued multiple times. Why they remained silent is kind of beyond the issue. But what happened was the trial court, without getting too much into the legalese and legal issues, the defense moved for a new trial, asked the trial court to let's redo this, let's get a new jury member, because they told the court, had we known that they had been sued, we would have used one of our strikes on them. They would not have been on the jury. And Alabama Supreme Court basically came back and said, it's up to the trial court. And, you know, reading through the tea leaves, anybody can see what the trial court may do with it. It's a serious issue. It compromises the entire process. I mean, that case, I think the injury happened in 2018, so it's a long, lengthy litigation process that got all the way through the verdict, and now it's at jeopardy of having to start all the way over.
Yeah, and I think it was Justice Cook, if I remember correctly. One of the justices wrote a concurring opinion that I thought was pretty enlightening to talk about the time, effort, energy, and expense that just goes into these trials, and to potentially be confronted with having to have a new trial and do all of this all over again based on, I think, what the justice perceived to be maybe we need to have a higher burden of proof.
Yeah.
Maybe we need to have a higher threshold to allow new trials to take place under these circumstances. But the law is what it is at this point in time. But yeah, I mean, who knows ultimately what the trial court judge will do, but it could be a new trial. You just don't know at this point.
Yeah, it's really tough. And, that's a balancing act of, as the parties, you put so much effort and so much time into it, you ultimately get a successful verdict, and then it's all at risk for something that you have no control over. And so that's why at the beginning of these trials, right at the beginning of the Voire Dire process, we are encouraging and telling the venire members that it's okay. We want you to tell the truth. Nobody in here will hold it against you. We just want to know. Because those members were not fit for that jury and would have been better for another one. And now the entire process may have to start over.
Yeah, and I know you do this because I do this. I always tell people to err on the side of disclosure. Don't sit on your hands. Don't think, well, maybe I should answer that, but I'm not sure I understood the question. Ask for clarification on the question, or stand up and just give your answer. And if it's something that the lawyers were not looking for, at least you've disclosed it, at least you've been transparent, and at least if you get on that jury, you can know that you disclosed everything. Because think about it this way, just human nature, if you get on that jury and you know that you answered a question falsely, incorrectly, or you didn't answer a question that you should have answered, you're not going to be focused necessarily on the actual trial.
Right.
The facts that you're supposed to be judging on, you're going to be sitting there periodically wondering whether or not, oh my gosh, what do I do?
Yep.
Right? Because disclosing that during the middle of the trial is not a fun or good position to be in if you're a juror and you're 3 days into a trial and all of a sudden you have this epiphany, hey, I think I need to disclose this, because that could easily result in a mistrial at that point in time.
For sure. And, most of these trials, we have adequate alternatives where if they're going to disclose it, I'd rather them do it in the middle of the trial, because you may have enough alternative jurors where you can go forward. But yeah, man, waiting until the end and the verdict comes out, and it doesn't seem like this was disclosed voluntarily. Like you said, good work on the defense attorneys, but it's tough no matter what. And yeah, we want the impartial and fair jurors to be able to think about nothing but the evidence in the case till the conclusion, and we don't want anything about, well, when is this non-disclosure going to catch up with me, right?
Great conversation.
Absolutely.
Appreciate you being here, and thanks to everybody for listening in or watching today. We really appreciate your time, your attention, and for supporting this podcast. We hope you enjoyed it, and we look forward to seeing you next time.